What are objections and when can they be made? We see that, I think, a lot in movies and television, and it's always so dramatic. I object or objection, right? But what is that and when can that actually happen?
Sure. Without getting into too much detail about what I do specifically, it differs in different court proceedings. There's some court proceedings are very formal. Criminal trials would be included in that, and other ones are less formal. I actually like about what I do that it's a little less formal, and we're not constantly objecting. So that it's actually they're actually relatively rare. But when you're objecting, you're basically saying that some of the rules of court or some of the procedural rules have been violated. So there are federal rules of evidence, and they basically, as we were talking about before, limit the type of questioning that you can do and the questioning tactics. And it's not for drama. It's basically just to avoid unfair questioning or kind of trap questioning and stuff like that. So an example before we talked about a leading question.
Right, that's what I was thinking.
That's a perfectly fine basis for an objection. Now, so
Let's talk about questioning a witness, right? This is the bulk of what our legal teams, the prosecution and defense, are going to do. Many of the students had questions about, like, how do you question a witness? So what kind of questions are lawyers permitted to ask, and what kind of questions or statements can they not make?
But it has to be relevant information. It can, and it can be positive or negative. You may be saying a lot of things that are really flattering about your witness that really have nothing to do with the hearing and are going to about all the charity work they're doing or something or whatever, but there are rules that may limit the stuff that you can bring in. So you can't make up stuff.
So you have to tell the truth.
Obviously, witnesses are sworn under oath, but also attorneys are officers of the court. They have an ethical responsibility. And
so for us, we work a lot on, as we're doing our writing, we follow a CER model, which is a claim, evidence, reasoning.
Okay.
Right. And so one thing that can happen often is if either the evidence or reasoning doesn't tie back to that claim, often it's like, you're going off topic or off track here, right? That's kind of what I'm hearing you say is like your questions to the witnesses have to be geared towards what that argument you're making is.
Yeah, I think that's a way of thinking of it.
Great. But what kind of behaviors are expected in a courtroom? What kind of behaviors are not tolerated? Not necessarily just for the defendant or the legal teams, but also for people that are sitting in kind of the public space watching a trial, for jurors, for other people in the courtroom. Like what are the basic expectations for behavior?
Yeah, well, without getting into too much detail, I mean, a lot of them are common sense. So for the people who are witnessing the hearing, the people who are observing, a lot of the trials are public, and the public has a right to see them unless there's special circumstances. So it's not any different than being at the theater or being just anywhere else where the people who are the ones being paid attention to are getting the respect of the people who are watching. So it's important if the people who are spectators have no role in the hearing, so they're basically never going to talk. And that includes family members and people who have a vested interest in the outcome. So they're just there to spectate. For the participants, there are places and times when they are talking, and there are very much places and times when you're not supposed to talk. Just because you get your attorney badge doesn't mean you get to act however you want, and you see that on TV a lot. Yeah. Opening statement, one person goes and their person goes. There are many times during an opening statement I've heard the other attorney talking, and just my blood is boiling because they're saying something I think is false or I disagree with. I have to wait my turn. Yeah. I have to just take notes, prepare, respond to that in the way that I can, and just make a good argument, because I'm going to do myself a lot more harm than good by angering the judge, who isn't the person who's going to make the ultimate decision, but can influence the way that the trial plays out for me.
So that's interesting. You said like it'll do more harm than good. Like if you were to interrupt during an opening or a closing statement the opposing side, what do you mean by that? Like how would that hurt your case if you did that?
Well, it may, in terms of the argument or the technical aspects of my legal argument, it may not hurt it at all. But judges and juries are human beings, and the human beings expect people to treat each other, with respect and a certain level of candor and deference. So, like, if you're just talking out of turn, if you're talking rudely, if you're making wild accusations that are just, it's going to turn a lot of people off to the merits of your argument that probably have a lot of truth to them. So, when I say more harm than good, it's just that people respond to other people at doing a good job, being prepared and professional, and not just flying off the handle and doing things they're not supposed to do in that setting.
So you can make it sound like the jury might, look at your behavior and feel like, oh, that person is you know, that person's giving me kind of a bad vibe, and that could influence their thinking.
Well, right, and that's the last thing that you want to happen.
Yeah.
You should be able to identify arguments in your favor, because it's very rarely the case that one side is completely right and the other side is completely wrong.
Sure. All right, now let's go on to some questions from the students that they had prepared ahead of time here. So first, Billy wants to know what advice you have for keeping calm and focused in the courtroom.
Yes, I alluded to this earlier. I'm usually pretty even keel, but I do have a competitive streak. And, I played sports, and there are some sports like aspects to being it's you versus someone else, and you
Winner, loser, kind of.
yeah, there's a winner, loser, and you've done your preparation, and you think everybody thinks that they should win.
Yeah.
But you're going to hear things during the court that not only are bad for your chances at winning, but sometimes feel personal. I've had people call me liars on the stand, whatever.
Sure.
And the witnesses, by the way, I didn't want to talk about their conduct, but they're not really supposed to ask questions of the attorneys
That's good to know.
or the judge, certainly. So they can certainly be reprimanded for that type of conduct also.
So they're basically just supposed to answer the questions they're given.
Yeah, they're supposed to respond to what the judge has told them to do and the questions being posed to them. And if it's getting out of hand, the judge really is kind of the gatekeeper of all that. So I've had to keep my calm and as I said before, wait my turn to make the arguments that I know are going to be helpful to me. And a lot of times the emotional response would not be the best option.
Sure. Yeah. It's kind of a sub-question to Billy's first part there. If you are, say, cross-examining a witness, and if their responses don't go the way you had hoped, what's maybe some wisdom there to go about continuing questioning those witnesses?
Well, that can be extremely frustrating, but there could be a lot of things going on there, and you have to control the things that you can control. So, like I said earlier, when you're cross-examining a witness that isn't yours, the best questions that you can ask are ones that you think you know the answer to that are helpful to you, and those should be based on facts. If they're giving answers that sound to you like they're not facts, that they're just fabricated or just factually incorrect, then you need to think about what tools you have to convince the jury of that. Maybe there was a deposition, or maybe they gave a witness statement earlier that said something completely different than what they just told you. If you point that out, politely and factually in front of the judge, they're going to lose all credibility in the eyes of the court and the jury. So that would be the type of tactic. But you will often get answers that you're not expecting. People will now remember new things that they haven't mentioned at any point to the authorities or elsewhere, and you need to be able to respond to that and anticipate it, but the direction of your questioning can prevent a lot of that.
Absolutely. Another question. Many students were wondering how a lawyer would defend someone if they knew the defendant was guilty.
Okay. You have a responsibility to protect your client and to put them in the best position to proceed, and it's really not your decision at the end of the day. If you do your job and the judge and the jury rule otherwise, then you've done your job, and that's just how justice works.
Yeah, so that's, I think, great advice, right? Like, it's not your kind of concern to think about, is this person guilty or not guilty, because you're just going to present the best case you can, and maybe the jury will find in your side, maybe they won't.
Well, in football, they say I'm not the referee. If you do something wrong or whatever, it's not your job to make that judgment. It's the person who's has that authority to make that judgment.
Good. All right, now, next question. Theo wants to know some advice on how to effectively question a witness. We've talked about...
I've already talked about the differences between questioning your own witness and cross-examining another. But I think keeping it simple is the main thing. You go to law school and you learn really complicated case law and legal jargon and all this stuff or whatever. And they don't really teach you how to do the job at all. And then you get in the real world and it's like, okay, I've learned this new language, this new way of this persona. And then your job becomes, I have to talk to real people and make them understand what I'm talking about in a way that's appealing, like relatable, and easy to understand. Nobody wants to be talked down to or feel, So in the questioning, you want to keep simple concepts. You don't want to kind of talk over people's heads. You want to not focus on too many different things at one time, and you have very specific goals for what you're trying to accomplish with the testimony, rather than just making every possible argument into something that's going to help you. There should be a narrative. There should be an explanation why your side is right, and your questions, as much as possible, should focus on doing that.
So again, this sounds like it fits in well with what we've practiced with our writing, right? Claim, evidence, reasoning, stay on target. But then also, we've talked a lot about don't assume your reader, or in this case, the jury, knows what you're talking about, right? So keep it simple in terms of, hey, if you're introducing a concept, that has to be explained clearly in order for the court to understand it. That if you're going to ask a witness a question, don't try to use all this flowery language. Just be simple and straightforward.
Yeah, and I think if you understand how to be an effective writer and to express yourself through writing, like that's 90% of the job of doing what an attorney does, because you have to make those arguments. You have to do it in a way that's relatable and understandable and efficient.
Good.
Hey there, history buffs. Check out part 3 with my interview with attorney Jeff Homuth coming soon.